Have you made a mistake in registering your business that is threatening the very existence of your business? Are you struggling with a very difficult shareholder or director? Today on Evolve Business, we will be discussing the essentials, understanding the legal implications of appointing someone as a shareholder or director of your business. So joining us virtually today is Mr. Daniel Imadi. Daniel is a lawyer with a wealth of experience in corporate and commercial law. Welcome again, Daniel.
Thank you, Batema. Thank you.
Now let's dive right into reading our letter from our viewer, and then we can continue with our discussion. Dear Evolve Business, my name is Karen. I started a business in 2018 and decided to register it as a limited liability company in 2021 after I realized that the business was quite lucrative. A friend introduced me to someone who claimed he worked at the Registrar General's department. I found out later that it was a lie. He helped me complete the forms at a fee and brought me my company incorporation documents within a few days. He told me that I needed at least 2 people to be directors, so I asked him to put my name and that of my husband down as the directors of the company, although my husband has no experience or expertise in my business industry. At the time, things were going on well between my husband and so I gave my husband 40% shares in the company. My husband and I are the signatories to the business account. My company is doing very well, but my husband and I are about to get a divorce. He never supported me in my business, but he's claiming that he owns 40% shares in my company. He refuses to sign documents and even checks for my suppliers until the divorce is done. I am so confused. My business is collapsing. Please help me. So Daniel, what are your views on current situation?
Karen is in a deep matter. Now, let's put it this way. Before we look at Karen's issue, let's have a basic understanding of what you need to do when you set up a company. Now, in Ghana, fortunately, we have what you call the Companies Act, which came into being in 2019. Now, this piece of legislation allows us to set up companies. Now, the basic requirement is that you need to have a minimum of 2 directors. Now, out of the 2, one must be resident in Ghana. The essence of this residency requirement is that at all times, we need to find somebody who would basically be in charge of the company or who would act on behalf of the company, because the company is just an artificial body and will act through persons, just you and I. Then the other thing is that for shareholders, the basic requirement is that you need to have at least 1. And for shareholders, the shareholder can either be a company that's a body corporate or an individual, just as you and I. So these are the 2 requirements. Fine, there are other things that as we go along, we may mention, but then you need to consult maybe a lawyer or maybe some other person who will be able to help you with that. But these are the basic requirements for a company. Now, for Karen's issue, I can just look at it and say that it's not, Karen will not be the first. She's not going to be the last. There have been others before her, and there are others currently, and there will be others after her who would go through such situations. But how do we mitigate these things? We will find out as we go along. For Karen, one of the things that maybe she should have realized was that she, being in a relationship with the husband, does not guarantee the husband rights to the company. So we would look at it from 1, being a director, and then 2, being a shareholder. Now, as a director, Karen, there are options available to her. What I would suggest to Karen is that, Karen, reach out to your husband. Tell him that, you know what, the company is collapsing. You are unable to meet your needs. You're unable to get supplies. you're unable to carry out business. So he needs to understand where you're coming from. Now, if he doesn't budge, my suggestion is that the Companies Act has elaborate provisions on how to deal with a director. Now, what you can do is that you can serve a notice to your husband who's a director, but you serve that notice on the basis that he's a director. Now, the law requires that you serve a 35-day notice to your husband who is a director. Your notice is to remove him as a director. Now, once you serve the notice, he also has the right to respond to the notice. Now, whether he chooses to respond or not, you still need to provide that notice. Now, the notice will elapse with a meeting. So it means that you can only remove him at a meeting, properly so-called. Now, this is a meeting of what you call a meeting of shareholders, because he's also a shareholder, so he'll be present. Now, once you have the meeting, you can just go ahead without giving any further reasons to pass a resolution to remove him as a director. Now, like I said earlier on, you can reach out to him, tell him that, you know what, we need to come together and get this thing sorted out. For him to budge, he has to actually resign or maybe play ball with you. But if he doesn't do any of these two things, you can then remove him at a meeting, properly so-called. Now, one thing you should know that for being a director of a company, it will be good or it will be advantageous if the person has expertise in that field. But then time has shown that you don't necessarily need to have expertise in that industry. So when you're choosing a director, be guided by the fact that the first thing is that get somebody who understands your business or who is into that industry. But let's say you don't find somebody who's into that industry. You can also look for somebody who qualifies to be a director. So one thing is that somebody may have an experience elsewhere. So for instance, let's assume that Karen is into the business of selling car batteries and car tires. So you can find somebody who is into that business or somebody who's into another kind of business. So for instance, the person may have a marketing background, the person may have a finance background, or even an IT background. Bring that person's experience to bear, in your field of work. So that's what I would tell Karen to look at.
So Daniel, if I understand you correctly, you're saying that expertise or experience in a particular industry is not relevant to appointing someone as a director of a company.
Definitely, it's not relevant. It will be good if you have that expertise, but then that should not be your focus. Your focus is somebody who can be a director. Now, the Companies Act has provisions on who cannot be a director and who can be a director. So my advice is consult a lawyer who would give you a list of who can be a director and who cannot be a director.
Okay, Daniel. So basically, can you briefly tell us some key qualifications of who can be a director in Ghana?
So certainly, number one, an infant cannot be a director. So that means that somebody who is below the age of the 18 years cannot be a director. Then for another qualification is that the person must be of sound mind. You can't just take anybody to be a director. The person must be of sound mind. And then the person must not be an undischarged bankrupt. So the person must not have, when we talk about bankruptcy, basically being unable to pay your debts. Mm-hmm. So you must look for somebody who is not in that category. So these are some of the things. And then you cannot appoint a corporate body as a director. So that means that a director must be an individual, that is you and I. So these are the basic things that you need to look out for.
If I understand you correctly, the law is looking at someone who is neither an infant or nor someone who is delirious, or so the person must actually be of sound mind in order for that person to become a director. These are some of the examples of the qualifications that the law requires. But the law does not require that person to actually have any relevant expertise. But from what you're saying, it is advantageous to the business if that person has relevant experience that will help the company to grow, right? Now, let's come back to Karen's situation. Karen has appointed her husband. Clearly, she was told that she needed 2 people, and she wasn't prepared to name anyone as a director at that point. But the first person who came to mind was her husband, and so she made him a director. And you're saying that because of her situation, she needs to either speak to the husband for him to resign because they are not seeing eye to eye currently, or if the husband fails to agree to resign, then she will have to go through the route of removal, which you have explained elaborately. What about the second aspect of Karen's situation? Because because of love, she gave this man 40% shares in her business. What about that? How is she able to as equally easily remove him from being a shareholder of the company?
Unfortunately, removal of a shareholder is a tall order. Now, we've had some examples like this in the past. Now, in the peculiar case of Karen, what she needs to do is, just like being a director, she needs to talk to him that this is what you need to do because the company is falling apart. And the company must be a going concern. Without a company, every investment that she's put into the company will amount to nothing. So she needs to appeal to his conscience, that is, if he has any, to look at it. Now, if he's unable to do that, that is, if he doesn't voluntarily leave the company, my suggestion to her is that she needs to go to the court for an order to be able to manage the company or to be able to find a way. Normally, the court may decide that, okay, you know what, Karen, you can either buy him out or he will buy you out. But these are some of the remedies that the court may provide. Now, what Karen should have done was to enter into what you call a shareholders agreement. Now, this is a piece of document that is done between or amongst shareholders of a company. It allows them to know how to manage the company. In fact, that document would have spelled out all these issues, how to go about it, the remedies for it. So my suggestion, maybe in the future, when Karen is able to extricate herself out of this, she could enter into a shareholders agreement with somebody anytime she enters into such a relationship. Now, because this is a familiar relationship, that is, entering into a relationship with somebody she knows, that is even the more reason that she had to enter into a shareholders agreement. So it is imperative that you do that.
Okay, thank you. So another key thing I noted was the fact that Karen had someone claiming to be a staff at the Registrar General's Department advising her. And clearly, this person did not give the right advice. And it is his advice partly that led Karen to where she currently is. So what do you have to say about that?
Now, for Karen, she dealt with the wrong person. Now, going forward, when she wants to maybe set up another company or do anything in relation to this company, my advice to her is to go to the Registrar General's Department. When you go there are a number of officials you can talk to. They can assist you with a number of things. But in order to incorporate a company, my first point of call is to go to a lawyer. When you go to a lawyer will be able to give you advice, to explain a lot of things. Maybe you don't need to set up this type of company. Maybe you need to set up another type of company. Maybe you need to do this. The lawyer will advise you on all these things. Sometimes when you're operating in a regulated industry, so for instance, a regulated industry like maybe insurance or banking, you can't just set up a company and that is it. You need to consult a lawyer to be able to advise you on your rights, who to appoint as a director. Because in some industries, you need what you call independent directors. That is, directors who are not related to any of the shareholders. So you need to know your rights. That's why I would advise that you consult a lawyer when you decide to, or when you conceive the idea of forming a company.
Thank you, Daniel. There's one more thing that she said, that her husband is refusing to sign checks for her suppliers. And because of that, I suspect she must be reneging on some of her promises. What do you have to say?
For that, it goes back to what we said. If he's unable to see reason as to why he has to sign the checks, it's important that we deal with the situation as at hand. So he's signing those checks as in his capacity as a director. That is why it is important that she needs to take the step of removing him as a director. That is if those two options fail. So one, his conscience; two, he resigning, and then the third one being removing him at a properly so-called meeting.
Brilliant. Thank you very much, Daniel, for your time and for joining Evolve Business with Boatema. This has been extremely insightful. So viewers, as Daniel rightly said, there are a lot of Karens out there. A lot of people have formed companies and put people's names on there who they have no relationship with. So I hope today's discussion with lawyer Daniel Imadi has been very insightful to you too. Hello, my name is Boatema Boating. Thank you for joining us on Evolve Business with Boatema. Subscribe for exclusive full episodes of Evolve Business with Boatema.